Fivaz.
Yes, Mr. Grant, when you're ready.
My lords, before we broke, I was about halfway through dealing with how clause 3, 4 and 4.1 interact and what clues we might take from other areas of the lease as to the meaning of landlord's fixtures.
Yes.
I would like, if I may, to pick up with what I say the two discrete purposes of these clauses now are. Clause 3.4, my lords, is a covenant, and it's a covenant with the landlord only. If we may turn it up, I know that this will be familiar to us. It prohibits the tenant from making alterations or additions to the demised premises or any part thereof, or cutting, maiming, altering or injuring the walls or timbers, all the internal arrangements, or removing any of the landlord's fixtures without having first made a written application accompanied by all relevant plans and specifications in respect to the lessors, and having received the consent of the lessors, and then paying the fees of the lessor and any mortgagee and their professional advisors. Now, it's my submission that effectively what this clause is targeted at is significant operations, major internal works, and in my submission that's made clear from the reference to needing plans and specs, the need, yes, to get consent, but also to pay the lessor's fees and any sort of mortgagee's fees, and of course the professional advisor's fees. That would be, in my submission, a relatively onerous clause for something, if my learned friend is right and they're to be read together, for onerous requirements for us to have to undertake, even to do some of our repairing obligations under 4.1. It's targeted, I submit, at operations that could alter the value of the landlord's reversion in 999 years, or any mortgagee's security. That's what it's looking at. Clause 4.1, by contrast, if we may turn that up, is a covenant between the tenant with the landlord, yes, but also any other tenants from time to time. And it says that the tenant covenants with the lessors and with and for the benefit of the owners and tenants from time to time. Now that obligation is to repair, maintain, renew, as has already been discussed. And it is, I submit, a standard repairing clause. What is important to note, my lords, is that it's an absolute obligation. It's the tenant effectively is in breach the moment that something that it is covenanted to repair falls out of repair. Now, and this, of course, in my submission, of course, does not require consent. My lords, if we step back and take into account some of the factual background, as I've said, this is a 999-year lease in an upmarket building in central London. The parties would be aware it's a valuable asset and a readily marketable one that has to be kept, of course, in good repair. Parties would also be aware that over the lifetime of the lease, works will have to be carried out to the flats, not least, of course, repair. There may be a wish for alterations, but at some point something's going to break that's going to need some work doing. Failures to repair, such as, for example, pipes and drain pipes, might well affect other tenants. That's part of why the covenant is with them. If our pipes break and it starts flooding the flat below us, those tenants have a cause of action against us. Clause 3.4, by contrast, doesn't do that. It's just between the landlord and us, this tenant, and of course there are references made to the mortgagees. So against that background, my lords, as I've said, my submission at 3.4 is based on effectively big internal works, transferring it from a one-bed flat to a two-bed flat, or a studio, for example. But there isn't any clear interest, I submit, in the landlord going further from those major significant works and controlling more than that. My learned friend has said the point of 3.4, clause 3.4 is control. I can't back away from that, but I don't accept that the purpose of clause 3.4 is to extend control all the way to, for example, the doors.
Is it your submission that there's no overlap between the two?
In terms of what it is they bite upon, my lord, as in what physical part of the premises, I think I'm constrained by the fact that walls appears in both to admit there must be some overlap. But my submission is they should be read as mutually exclusive as much as possible. And in terms of the work carried out, I submit that there isn't an overlap. Something either goes under 4.1 or it goes under 3.4, but the two generally do not meet, and I'll come on to mutual exclusivity in a moment. My lords, reference has been made to ensuring, and I think this comes from the decision of the FTT, both commonality of doors and fire safety. And in my submission, that's not an adequate basis on which to consider that clause 3.4 is intended to extend to the front doors. In terms of this commonality of doors point, it's really the aesthetics and the ambience that I understand, certainly the FTT and my learned friend, to be getting at. But my lords, I mean, the majority of these leases, I don't think it's contentious that the majority of leases in this building are on extraordinarily long leases, 999-year ones. And I don't accept, and in that basis, I would submit that the landlord's interest in keeping commonality of doors is really much reduced in that. And I don't accept, or I submit in fact, sorry, I should phrase this properly, that the parties would reasonably bargain to allow a landlord to superimpose their aesthetic tastes over the aesthetic and security preferences of the tenant. The flat is, of course, the tenant's asset, not the landlord. And security I've discussed earlier.
Well, sorry, why do we get into aesthetics with either of these clauses? I mean, surely aesthetics is the province of, for example, clause 4.2.
My lord, my point was merely that commonality of doors was, ensuring commonality of doors was one of the reasons why this clause extends to front doors. And my point was that aesthetics would be an odd fit for that. I mean, if aesthetics is managed by 4.2, I'm perfectly happy to accept that.
But I mean, if your test is whether the alteration is significant, I would have thought changing a front door on any view is a significant change. And that also, I'm not really sure you can spell that out of clause 3.4. I mean, on the face of it, you're in breach of it just by banging a nail into the wall to hang a picture on. And you may say that's de minimis, but I would have thought on any normal use of language that's an alteration or injury to any of the walls.
Well,
just goes to show that, I mean, landlords are very much prone to a degree of overkill in the covenants they seek to extract from their tenants. That's just...
Well, it rather does, my lord, and that's why it's my submission that the two clauses have to be read together somewhat sensibly. And it's in my submission, as you say, as my lord says, it would be overkill, I submit, to require us to submit plans and specifications and pay any mortgagee's professional advisor's fee.
But I think one would read the reference to plans as meaning, sort of, if relevant or if necessary. It's not, so to speak, confining the scope of the clause, I would have thought, to works which are so significant that they're going to involve, necessarily, plans and specifications. After all, the word alterations, on the face of it, could hardly be broader. And it's only in the case law that we're told that doesn't extend to alterations of a non-structural nature.
Yes, my lord, I accept that. But it's the fact that the case would, of course, be part of the background to interpreting this lease that, again, it demonstrates that alterations, I would submit, is here, as in previous case law, confined to matters of a structural nature used in the, I should be clear, used in the Bickmore and Dimmer sense. I'm not necessarily conceding that structure in Bickmore and Dimmer is the same as structure in Boswell. my lord, can I be of further help on this point? To the extent I've been of any help already.
I mean, I suspect a lot of these points are potentially a bit double-edged, but that's not a criticism, it's just a reflection of the puzzles which cases like this throw up.
Yes, my lord, quite so. I think I'm constrained to accept that there are perhaps a lot of double-edged points here. That's part of why interpretation is a reiterative process.
Yes.
And why my first submission on based purely on the language of this first is, and what is a landlord's fixture, and why a door is not a landlord's fixture, I suppose is perhaps the strongest one.
Yeah, I mean, that has, at least on your argument, solid support in the case law, and is a sort of intelligible principle which one can apply, although quite how it applies to any given set of facts may be difficult. Of course. Conceptually, there's no great difficulty about applying a test of that nature. Yes. Maybe that is your strongest point.
Yes, my lord. The other reason that's given, my lord, by the FTT, and again I think by my learned friend this morning, for the landlord's interest extending to being able to control our doors is this fire safety point. And my lords, as I put in my skeleton, there isn't in fact any evidence or legal submission that fire safety was much considered either in the 1970s or the 1990s. Of course, recently, yes, it's become of paramount importance for very tragic reasons, but that's not in my submission an aid to interpretation of what the parties might have been thinking in 30 to 50 years ago. Really, there were two things. Either there was a legal obligation, there are legal obligations on the landlord to ensure fire safety at the relevant time, or there weren't. If there weren't, and I'm conscious, my lord, that it isn't in your bundle because a lot of more recent fire safety laws, like the Fire Safety Order 2005, postdates the lease, as does the Fire Safety Act of exactly 2 months ago. But if there wasn't any legal obligation in my submission, then there really is no basis on which to say that it would have been one of the animating background considerations of the parties, and no basis on which to say it's an aid to interpretation. If there were relevant fire safety obligations at the time, and I'm conscious this isn't before my lords, either way, in my submission, it might well be caught by another clause, which is clause, and I don't think you've been taken to this one yet, largely because it wasn't foreshadowed in my skeleton, clause 311 of the lease, which is at page 51. Now this, my lord, puts an obligation on the tenant throughout the said term to comply in all respects at his own cost with the provisions of any statute, statutory instrument, rule, order, regulation, other direction, made or given by any authority or the appropriate minister or court, so far as the same affect the demised premises, and whether the same are to be complied with by the lessors, the tenant, or the occupier. There isn't the material before you, and I don't intend to go into an interesting and detailed discussion of fire safety law, but the point is, if there was a legal obligation relating to fire safety, and clause 311 might well bind the tenant on that. So with respect, I submit that fire safety, again, can't be an animating ground or an animating reason why clause 3.4 and landlord's fixtures should be held to extend to doors. My lords, unless I can be of any further point on that, that brings me to any further help on that. It brings me to my next point, which is about whether the two can be read together. And my learned friend has put first and foremost in his submissions that they can, because there is a implied duty not to unreasonably withhold consent under 3.4, and therefore the two can be read synergistically. I submit that's wrong. First, my lord, it doesn't actually absolve us of any sort of liability, at least as against any other tenants. Clause 4.1, as I've said, is a covenant between us and other tenants.
Well, there can't be a legally binding obligation vis-à-vis the other tenants in 1970, can it?
Sorry, my lord?
I mean, the other tenants, they're not parties to the lease. Are they? They weren't.
No, my lord.
No.
don't believe they are, but it is in a covenant made with and for the benefit of the owners.
Well, I know it's said to be, and you can't make a contract with somebody just by naming them to a document they're not a party to.
Not as a contract inter partes, my lord, no.
Well, that's the only form of contract.
Well, sorry, I'm just thinking of the position with regard to deeds. Which
I see. Well,
which this is, and I've forgotten the technical term of it, a deed signed by one party enforceable to another named in it, even if that other party is not a party to the deed.
well, I quite take your point. Certainly, it evinces an intention that the benefit of the covenant in one way or another is to inure not only to the landlord but also to the other tenants. So,
yes, my lord.
and possibly, I mean, there could even, for all I know, be some scope for a sort of scheme of arrangement type argument under which they could be mutually enforceable obligations. But there's no suggestion of that in anything I've seen.
No, my lord, and I'm not going to make that suggestion on the hoof.
No.
So there is, as I said, a suggestion, at least, to put it in that way, that our obligations under 4.1 were supposed to at least be for the benefit for and perhaps enforceable by other tenants. And the reason that raises a problem, of course, is because if, say, we're in breach of our 4.1 obligations and the flat below is flooding, any additional time that the tenant has to spend getting consent from the landlord is time in which that flooding is getting worse. It's the need to get consent to repair, renew, remove a landlord's fixture. Say, my learned friend has repeatedly referred to the pipes. So, for the sake of argument, assuming that's correct, to remove a faulty bit of pipe and input a new one is time in which, my lord, the tenant's liability is frankly increasing. And even if the landlord does not unreasonably withhold consent and is very reasonable about it, there's still this time element where matters are getting worse for the tenant in terms of its liability to other parties. Second, my lords, forgive me, there are these practical difficulties, and another example of that is given in my skeleton. So, say, for example, that the front door is damaged, so it doesn't work, and the tenant wishes to replace it. I've outlined already the importance of a front door to a flat. It is, in my submission, just practically difficult and frankly uncommercial to expect a tenant to have to wait to secure his own home on making an application to and getting consent of a landlord and potentially any mortgagees or the landlord then potentially consulting with agents, mortgagees or other professional advisors. My submission, my lord, is that clause 4.1 just doesn't anticipate that, and that it shouldn't therefore be read subject to sort of 3.1 consent requirement. The third difficulty with trying to read these together, my lords, is that they create a certainty problem. As a tenant, in fact, as we see from the fact that we're all here, a tenant needs to know if it's in breach of covenant in order to avoid forfeiture. If there is an obligation to repair, which arises instantly, the tenant needs to know if it can undertake those repairs or if it has to, for example, wait and get consent. And I accept a landlord cannot unreasonably withhold consent, but it places a burden on the tenant of asking. And if for whatever reason the landlord says no, or consent is not forthcoming, it then places an obligation on the tenant again to decide if the landlord's been unreasonable, maybe make an application, maybe go ahead and do the works anyway and incur potential liabilities. So for those three reasons, my lords, in terms of this 4.1 point, the practical difficulties and the certainty problem, I submit that the two clauses have to be read as mutually exclusive as possible. And with that in mind, I submit that it supports, albeit obliquely, a definition of landlord's fixtures, which leads to as minimal overlap as possible. there's certainly no support, I submit, in clause 4.1, the proposition that the door is a landlord's fixture in clause 3.4, and is on a Judge Bridge was right. So to note, my lords, those are really my submissions on grounds 1 and 2, but this landlord's fixtures ground. Can I be of any further help, or would a summary assist at all? Or would you like me to move on to ground 3?
I think we can move on, thank you.
Forgive me, my lord. I spoke too soon. There are, of course, these various other points that are raised in criticism of His Honour Judge Bridge's decision. I'll take those fairly shortly, if I may, because I think the meat of the actual decision for this court has already been discussed. My learned friend took this court to Stokes and Costain. My lords, all I submit that we get from that is that a tenant cannot remove a landlord's fixture, but I don't think that's materially in dispute between my learned.
Well, it was an entirely different question. It was construing the word belongs in legislation relating to capital allowances.
Well, yes, my lord, I really think it's by the by.
Yeah.
The second point my learned friend makes is certainly at paragraphs 39 and 40 of his skeleton on this point, that Bickmore and Dimmer catches alterations, and therefore, alterations have to be structural, and therefore landlord's fixtures must go further. My simple point there, other than what I've already discussed, is that rather assumes what we're all here to prove, which is that the landlord's fixtures extends to doors, and that the intention was that it should so extend. I submit that there isn't actually any further, it doesn't materially move matters onwards. Third point my learned friend makes is a reference back to the Upper Tribunal statement that it would be counterintuitive for something to be both a fixture and part of the demise. My lords, I struggle to understand that particular bit of His Honour Judge Bridge's decision. I read him as simply making the point that the door is the essential component of a flat at paragraph 44, and then drawing a distinction between part and parcel of the realty and a fixture at paragraph 45. But if the court considers that what Judge Bridge is actually saying is that something can't be part of a demise and a fixture, that's not something I feel able to support. We then get on, my lords, to this derogation from grant point. Again, my reading of Judge Bridge's decision and the reading that I urge on you is simply that when he's referring to derogation from grant, he is emphasising how important a front door is to a flat demise. What he's not saying is if a front door is a landlord's fixture, then automatically there is some sort of derogation from grant. I don't think he's saying that at all. And that can't, as I said, that can't, I submit, be read into his points.
I mean, it's another way of making that point to say he read in context, he's not using the concept of derogation from grant as a kind of legal technical term, but just a sort of common sense proposition that when you take a lease of a property to live in, you expect to have a front door, and you would be pretty displeased, put it mildly, if you turned up to collect the keys and found there weren't any keys because there's no front door.
Absolutely, my lord. And I know my learned friend isn't making the point that calling it a landlord's fixture gives them the right to remove the front door. But by giving them control over whether we can replace the front door, particularly if it's damaged, it has the potential for problems down the line, I think is the point that's being made.
Well, that may be so from your client's perspective, but I can also understand from a landlord's perspective, it may seem a little surprising, to put it no higher, that a fairly radical transformation, such as swapping the existing front door for another one without even telling the landlord what you're going to do, it's a little bit surprising to find that slips through every crevice in the drafting and doesn't get caught by anything.
I can see how a landlord would consider that, would see that being the case, my lord. My submission, of course, is that the submissions I've already...
I mean, that's why arguments based on what one might expect do seem to me a bit double-edged.
Yes, my lord. I shall perhaps leave that there then. The burden of proof point has been discussed, and again, I think my Lord Justice Henderson encapsulated it earlier with what His Honour Judge Bridge was saying with regard regard to burden of proof. He wasn't making a decision based on burden of proof. My lords, that brings me to this ground 3 renewal point, and I am mindful of the tenor of judicial interventions earlier with regard to that, and therefore I'm going to alter it slightly and submit primarily that because of the reasons I have already laid out regarding not reading clause 3.4 and 4.1 together, if something is a renewal within what might understand to be a renewal in clause 4.1, then it shouldn't, by the same token, be considered a removal in 3.4, which is where, my lords, I get the proposition, and perhaps putting it in my skeleton as the ordinary English reading of the word remove was wrong. But it's from that reasoning that I get the proposition that removal here in clause 3.4 means no replacement. My lord, it's said against me that renew adds nothing to repair, an obligation to repair, and whilst I join my learned friend in not explicitly asking this court to decide the meaning of the word renew, particularly in a renew repair question, which is in fact quite vexed, I would refer, my lords, to the passages from Dilapidation's Modern Law and Practice that were discussed earlier, where the tenor of the renew versus repair, the meaning of renew versus repair was discussed. And if I can ask my lords to turn up tab 3, internal page 87. I'm not going to suggest, my lords, that anything we're about to look at is authority for the proposition that renew automatically means something more than repair. My point is simply going to be that it's a subtle question to be determined in each lease, and that it's not safe to assume that renew automatically means nothing more than repair. My lords, at page 87 there are a number of extracts from a number of cases, and the sidelined passages from Hunt and Optima, Cambridge, which is a decision of Mr. Justice Aikenhead in 2013. If I could perhaps ask my lords to read paragraphs 111 and 112, which is where the red lining is.
Yes.
Obliged, my lord. And if I could perhaps, my learned friend has already taken me to paragraphs, I think it's 428 and 429, onwards, which again gives a helpful summary of effectively where the case law is at. My point, the proposition that I put to this court, my lords, is that in the context of this lease, renew might well add something to repair, and that it allows the tenant, I should say, in effect, to prophylactically renew an item for which it is responsible. There's nothing that I submit, and it would, in my submission, it would lack commercial sense to suggest that a tenant, when it's under an obligation to renew various items, has to wait until they're out of repair and is therefore in breach of the lease, liable to the landlord, potentially liable to other tenants, before it is entitled to undertake any sort of renewal. My submission is that the clause 4.1 doesn't go that far, and that therefore, my lord, what it does do is allow this sort of, as I say, this allow something to be renewed prior to it being in disrepair.
That's a rather startling submission, isn't it? I mean, if that's right, it implies that in any case, a tenant subject to a fairly standard form repairing obligation is free to take matters into his own hands and begin changing the layout of the property, the way in which individual bits of it are constructed, or so on and so forth, to accord with his personal tastes, without in any way falling foul of any covenant. It seems something most landlords would not be at all happy with.
My lord, I hadn't considered the effect of my submission to go quite that far. Certainly don't think it extends to altering the inside of, undertaking sort of willy-nilly alterations to the inside of the property. The point is it's obliged to do things like maintain and renew, say, pipe work. And my point is simply it can take out pipes and put in new pipes before those pipes have sprung a leak. That's as far as I was intending to put the point.
Then again, if we apply that to a front door, we have a purpose-built block of flats with, 168 front doors in it. One would have thought the landlord might well be anxious to maintain some degree of control over just the appearance or the workmanship or the general type of door which is to be used throughout the block. So, again, to say that you have a right of, so to speak, a right of preemptive repair, enabling you to entirely unilaterally change the nature of your door, is at first blush a fairly startling one. I mean, it may be on the facts of this particular case, your client was entitled to do it, but it's by no means a self-evident or unsurprising conclusion, to my mind, anyway.
Well, my lord, well, I suppose, in terms of what the point my lord made about what a landlord would expect regarding, say, the commonality of doors, I don't have much more I can say other than what I've already said on that, which is actually that there isn't any clear commercial reasoning, or one can expect sort of some commercial reasoning from the landlord's view, but the points that have been given to support that commonality of doors point I submit aren't satisfactory.
And the fact is that we have really very little evidence here.
Yes.
I mean, the first tier tribunal makes virtually no relevant findings, and of course the appeal was dealt with on paper. So,
yes, my lord, and that I should make the point I'm not asking. I think my learned friend said in discussion with, or on questioning from my lords earlier, that there's no evidence of disrepair. That is a finding that the FTT made, and I can't go behind. It's not something that my client accepts, but there's nothing I can do to put that to you here.
yeah.
My lords, I'm not sure there's much more I can say on this 3-4-1 renewal point. Unless I can be of any further help on any aspect of my case, that might well be it from me.
Well, thank you very much, Mr. Grant. Let me just check. Nothing else, I think, from any of us, but many thanks. So, yes, Mr. Fieldsend.
Yes, thank you, my lord. As I understand my learned friend's submission with reference to clause 4.1 and the use there of the word fixture, is that the items enumerated before identified what was there at the time of grant, so that the interpretation to be given to the fixtures and additions were things that were brought onto the land post-demise. That seems, or I would respectfully submit, seems to be putting colour to the expression fixture that's not found in the case law. There's no temporal test to whether something is a fixture or not, beyond what is said in Boswell and Crucible, which is that it's something that's affixed to the structure after its completion.
Well, I mean, that is a temporal test, isn't it?
No, aside from that, but this was being said in terms of the demise, is that that a fixture is only something that is an object that is affixed to the land is only a fixture if it is affixed post-demise. That was the act of my learned friend's submission when looking and identifying the meaning of the word fixture as found in clause 4.1. That cannot be right. How does that then deal with landlord's fixtures? Because anything brought onto the demise afterwards is going to be there for the better use and convenience of the demise premise for the purpose of the tenant. That would be a tenant's fixture.
Well, would it? I mean, that's, again, that rather begs the question, doesn't it? It will only be a tenant's fixture if the tenant has the right to remove it.
No, no, because, sorry, respectfully, I disagree. Because the question of whether he has the right to remove it depends on what the nature of the item. That's what Climian Wood deals with, when it's to do with the better convenience and use of the premises. So it's a tenant's fixture because he has a right to remove it. He has a right to move it because of the nature of the fixture. It's brought onto the land by the tenant for the better convenience. That is what gives it its classification as a tenant's fixture, and that is in turn what entitles the tenant to remove it. So my learner's friends, there would be a void. Where would the landlord's fixture fall?
I mean, a number of judges have expressed some difficulty and puzzlement at the whole concept of the landlord's fixture, and in the end, it just seems to be a sort of negative concept. It's a fixture of a type which the tenant doesn't have the right to remove it, and therefore, so to speak, by default, it's a landlord's fixture because it remains affixed to the premises, and there's no right for the tenant to go off with it.
So, but my learner didn't give any examples. It's difficult to think of an example which, if a fixture is only something on the meaning of this lease, and he seemed to be saying this lease had its own meaning. He was saying that a fixture is something that is brought on or affixed to the land post-demise. But the lease uses the expression landlord's fixture. So if a fixture is something that's brought onto the land post-demise, what is encapsulated by the expression landlord's fixture? Because things brought onto the demise post-demise are going to be for the better convenience and use of the demise. Such items are tenants' fixtures. So it renders without meaning the expression or the words landlord's fixtures as found in the lease. That cannot be right. When one considers what was being said in Climian Wood, it echoes really what was said in Lambourne and McLellan. I don't accept that in Climian Wood the court had in mind this threefold classification that Lord Lloyd adopts many years later in Leadstone and Morris. Climian Wood was differentiating between chattels, items that are made to completely part of the land as being essential to its convenient use that even a tenant couldn't remove them. And then he says an example would be doors and windows. And then items which are brought on by the tenant for domestic convenience, which he labels tenants' fixtures. So that doesn't address this question of what is a landlord's fixture. Falling within that test, if the things that are brought onto the land as being essential to its convenient use, even that a tenant can't remove them, and if we are saying that assimilates with category C of Lord Lloyd, then all your sanitary apparatus, your radiators, your pipes, those are then not fixtures. That can't be right. I mean, that, again, it ties in with this point on functionality. Lord, said that, well, if the tenant turns up, you would expect to see a door there, and if he isn't, then he's not getting what he wanted. Well, if there was a door and he opened it, he went in, it was completely stripped bare, so it couldn't be used as a functioning flat because there was no sanitary apparatus, there was no mechanism by which he could access water. Then again, he would be equally disappointed. So if the test is one of functionality, and if something is required to enable the property to function as a flat, and if an object which enables the property to function as a flat is not a fixture, and again you come back to this problem that that analysis encapsulates all the things that one might traditionally think of being fixtures, pipes, etc., apparatus. Another way of testing the analysis is this. You are asked to consider or keep in mind the possibility that the building itself, so that's the apartment building rather than the flat, but the building itself did not have a lockable door. There's no evidence, and so you're asked to keep the possibility of that alive. So what happens at some point in time when a door is then put in? What is the status of that door? Because it's not part of the original structure. It wasn't installed at the time of construction. So would that door be a fixture?
But it wouldn't be part of the demise premises anyway. So.
Well, no, it's not part of the demise, my lord, because it's applying and looking at the test in Boswell and Crucible by saying, well, is something affixed to the structure? Well, if you have a building, it's built without a door, it's got nothing to do with the demise. You have a building, which is the apartment block, and it's built, and you've been asked to keep it open in your mind to the possibility that there wasn't a lockable door at the time. There was an opening. But at some point later in time, a door is affixed so as to close off that opening. What is the state of that door? Is it affixed?
I didn't think that was the example. What I thought we were being asked to keep in mind was the possibility that the block of flats door on the street wasn't lockable.
Yeah.
It wasn't anything to do with the door into the flat.
No, I'm not saying that. I'm saying, so you build a block, you build an apartment block, and within it there are flats. Each flat has its own door. But the access way into the door from the street, or the opening from the street, is without a door. A door is then installed. What is the status of that door? Because a landlord's fixture is not something simply known to landlord and tenant relationships, because as we've seen, it can arise in freehold as to whether it passes to the mortgagee on the mortgage of a demise. But it's a way of testing the proposition that a door is part of the structure, because a door can be brought in afterwards. And again, if one thinks about the windows, I'm not even looking at the stark or significant windows that was found in Boswell and Crucible stills. The windows are built into the structure. They are part of the structure. A door is affixed to the structure. It's attached to the structure. It's not part of the structure. It's not built into the structure.
Well, I'm sort of slightly puzzled as to why one can't view a door for these purposes as being effectively built into the structure in the same way as windows and so forth, or indeed in the same way as if, a one-story extension were added, or some other change were made. I mean, of course, you're right that a door is, so to speak, physically separable, and indeed may well be assembled, will be assembled off-site, manufactured off-site, brought in, and then attached. But looking at it from a sort of functional perspective, it might seem rather artificial to distinguish between front doors on the one hand and windows and other more obviously built-in parts of the structure on the other.
Because the functionality has to be with the nature of it being a flat, because it is conceivably possible to have a building without a door. It doesn't stop being a building. So the question of functionality brings you back to the nature of what is behind the door. And that then brings you back to the point about the sanitary apparatus, because you end up forced to then differentiate.
Just in case it matters, I've got to tell you, I'm not persuaded that there's an obvious, simple difference between how you put a window in a building and how you fit a door to a building. I can't believe the case is going to turn on how you fit windows in and how you
can have hinged windows.
Indeed. Exactly.
Yes.
Among other things.
Not to mention French windows.
No, I mean, I've hesitated to be drawn into any discussion about the quality of removability or the steps that are taken to remove them, because that is one of the reasons why in Leasehold and Morris, certainly from Lord Clyde's perspective, he says, well, let's try and avoid this. It's an unsafe term because you end up confusing the question of affixation and removability. So that's why I potentially. My lords, on the point of prophylactic measures, I mean, there's case law to deal with the ability to take preventative measures falling within repair. So So it's not necessary to read the word renew in the way that my Lord friend suggests.
You mean case law on the stage at which it is legitimate for a tenant who is bound by such a covenant, as it were, to preempt events by...
It's about to burst. I can't touch it until it bursts.
Right. I mean, that sounds like common sense, but it must be some kind of criteria in which...
Yes. Well, and indeed the common instance is 5 yearly cycles of repainting. You're allowed to do that in execution of your obligations under the repairing covenant, even if any particular part of the building, you could say, well, it doesn't need to be repainted till next year.
My Lord, yes, and then hidden beneath all of this is the historic implied covenants using the tenant-like manner. So if you know something's going to happen, then the requirement to step in. So I don't think it adds to the analysis to say renew is there to cover that eventuality. My own friends seem to be saying, we're trying to draw some distinction between clause 4.1 and clause 3.4, saying that it's there. Clause 4.1 is there. Its purpose is to protect other tenants, where clause 3.4 isn't. That's the reason why you have control over alterations, so that somebody doesn't knock through a structural wall. It doesn't just affect the landlord; it can affect the flat above. The only final point, my Lord, is no, 2 points actually. Just continuing the moment with clause 4.1. My learned friend says they're mutually exclusive, but he doesn't deal or address the mirroring of the word fixture in the two clauses. It's the repeated language in the two clauses that shows that there was an intention that they work together. Well, I think the final point I would wish to raise is this, which is my Lord Justice Henderson referred to the traditional position of how people back in the 1970s, when leases were drafted, and what might be considered to be walls and what one could do with walls. But if one goes back to Leakstone and Morris and thinks about what Lord Lloyd and his adoption of the threefold test, he identified and acknowledged that traditionally there was a twofold distinction. Traditionally there was a twofold distinction between a chattel and a fixture. So if one is thinking about a draftsman who has in mind a traditional binary distinction, then the expression fixture in a lease is there not with in mind any third category, but rather to draw the distinction between a chattel and a fixture. That is consistent with the traditional approach to the distinction between an object that doesn't form part of the land and an object that does form part of the land.
Yes.
Are you making a point about timing of authorities and when this lease is that the point you're making? This is a 1970s lease, and Lord Lloyd's judgment was in 1997.
I had written that submission down.
Oh, well, I've said it.
And I was
there you are.
I was more anchoring it on the because I think a problem with it is one would have to probably trawl back through, because it's anchored on woodfall. One would have to trawl through.
Well, exactly. One need to put archaeology to see when Woodfall first used that formulation.
Which is why I sidelined, but put it in that other way, which is that there is definitely a recognition of a traditional.
Well, perhaps again, it shows it's dangerous to speculate. I mean, even what I was saying about traditional forms of construction may have been a bit,
yes,
well, not anchored in any evidence in this case, so probably better avoided for that reason.
So unless I can assist any of you any further.
Well, no, thank you both very much. I mean, like so many of these cases, the question is easier to ask than it is to answer, so we now have the benefit of your submissions, for which we're very grateful, and we will take time to consider our judgments and let you have them in draft in the usual way. I'm sure you know the normal rigmarole, which is we will ask you for any corrections, typos and obvious mistakes, but not to re-argue matters and consequential matters. We hope you will be able to agree between yourselves. If not, brief written submissions on points of disagreement, and we will resolve them on paper, and hand down will either be virtual or so to speak, real, depending on circumstances. But either way, no attendance will be needed. So, thank you very much indeed.
Well,